Thanks everyone for coming. I'm Sonia Gardiner. I'm from the Office of the Public Advocate and I'm in the Senior Medical Treatment Decision Officer role. Today I'm here to do a presentation on the Medical Treatment Planning and Decisions Act. The presentation should take about an hour and there'll be a chance for you to ask any questions after that. So, as our first slide says, the Medical Treatment Planning and Decisions Act of 2016. And what the presentation will cover is this Act, which came into effect on the 12th of March, just of this year. So our presentation will go through explaining what advanced care planning is under the Act and what the medical consent process is for patients who do not have decision-making capacity. The Act now has a shift away from a best interests principle, and it talks about a person's preferences and values. So getting to know what's important to the individual of what they value about their healthcare and their future medical treatment, and getting a sense of what their preferences might be, whether to consent to or to refuse a medical treatment. So, advanced care planning under this new legislation. So from the 12th of March in Victoria, adults and children, so this Act is inclusive of children as well as adults. What children and adults can do is make an advanced care directive, and they can appoint a support person for their medical treatment decisions. Adults can also appoint a medical treatment decision maker. We're going to go through these three things in a moment, but essentially children can't appoint a medical treatment decision maker because it automatically defaults to their parent or their person who has guardianship or parental responsibility. So, an advanced care directive, and we need to think here about our language because the language of advanced care plan is quite familiar out in the community, and we may have heard of also end of life document, goals of care document. They're all indicating advanced care planning, but an advanced care directive is very distinct because it is a legal document. So, an advanced care directive under the Act sets out two components. It can be a values directive, which is the person's preferences and values about their health care and about their medical treatment. And then there's the instructional directive, and that's the binding legal instructions upon a health practitioner. So an advanced care directive can only be in relation to medical treatment of that person, and it's then for in the event that they lose decision-making capacity. That will then inform in the future what that person has consented or refused their medical treatment to be. So if we start to look through what that means, the values directive is more of a statement or a story about a person's preferences and values. So it's where, as a person, I may say what's important in my life in regards to my health care. What do I value most about my health and how I might want medical decisions to be made for me in the future. So I've written that as a statement or a bit of a story, and that values directive is then something that must be considered by my medical treatment decision maker in the future. So there's no particular prescription of what you must write in a values directive. It is that indication of what's important to me. That's because the Act that we start to talk about a little bit more is that when someone is making a decision for you because you've lost that decision-making capacity, a decision that's made about medical treatment should follow what that person's decision would have been if they had had capacity to make that decision. And where the Act now talks about consenting to treatment but also refusing treatment, if people are doing a values directive, that would give a basis for that medical treatment decision maker to then have a sense of what that person may have wanted in that scenario. So doing an advanced care directive, people may choose to do a values directive and an instructional directive. They may choose only to do the values directive, or they may choose only to do the instructional directive. So again, that concept of choice and empowering the person to make their own decisions for what makes sense to them. So if that's the values directive, which is a statement, a story about a person's preferences and values, the instructional directive component is a statement of a person's medical treatment decision that's directed to the patient's health practitioner. So what that means is where a values directive might have told a story about what's important to my healthcare, how I would like decisions to be made, what someone should think about whether they're deciding to agree or to refuse a medical treatment. Your instructional directive is more clearly stating what you would consent to or what you would refuse for a medical treatment that is then being offered to you when you lack that decision-making capacity. And so as it says, it takes effect as if the person who made it has consented to or refused the commencement or continuation of the medical treatment. So if you have a patient in your hospital and they have made an advanced care directive that has this instructional directive, and so your patient's since lost their decision-making capacity, you've got a medical treatment you're wanting to offer to that patient, they can't consent or refuse themselves, but there's an instructional directive. What that instructional directive says, if it's relevant to the situation of what you're offering as treatment, then it is that instructional directive that has given you the consent or the refusal. You don't then go and ask a family member what their decision is. You don't ask a medical treatment decision maker, well, do you consent to this treatment for your mum? Do you refuse that treatment for your mum? Because if they have an instructional directive and it is relevant to the medical treatment that's being offered, then the health practitioner is getting that consent or refusal from that instructional directive and no one else. So we don't yet know how these may kind of play out in reality. In terms of the instructional directives being witnessed, one of the witnesses has to be a registered medical practitioner. So the intention seems to be that if there's a registered medical practitioner, they would be able to unpack any statement that a person might say in their instructional directive. So if you think of a patient who has done an instructional directive, and in that as a statement it says, I refuse all breathing machines. Now, if you as a health practitioner have that instructional directive in front of you, your patient who can't make a decision is requiring a surgery that will effectively be curative of what that medical condition is, but part of their recovery from that might be after surgery needing 20 minutes on a ventilator. They've gone through their recovery, the ventilator is then not needed, and that patient goes on and is healthy, lives their life, and it's been an effective medical treatment. If, however, as a doctor or a health practitioner, you're seeing a statement that says that the patient refuses all life support, that could mean that then the patient can't have the life support for that 20 minutes that would have otherwise created a successful treatment. So the intention of having a registered medical practitioner witnessing would hopefully be that if the patient has said, I refuse all breathing support, breathing machines, that the doctor would then say, well, what is it you mean by that? Because if there was this situation, this is what would happen. If it was this situation, this is what would happen. So to try and get the patient then to be a little bit more explicit or expressive in what they're actually meaning. So an example could be if I'm a patient and I've written, I don't want any breathing machines, and the doctor says to me, well, you might need surgery. You can have a breathing machine for 20 minutes. It will otherwise be successful. Is that what you're meaning? You wouldn't have that breathing machine. That's not going to be successful. I say, no. As the patient, I mean, I saw my brother suffer through motor neuron disease. And when he got to the end stage of that disease, he was put on a ventilator, and that was awful for him. It was awful to watch. It didn't seem like a good quality of life. So that's what I mean. I wouldn't want a breathing machine if I got a diagnosis of motor neuron disease. So hopefully that registered medical practitioner helps me unpack that so I can be a bit more specific in an instructional directive. So it's likely to be challenging when they come up for health practitioners for you to be able to interpret, are they relevant to the situation that you're facing? And being these have only been created since the 12th of March, we're going to have to wait and see what the reality shows us as to how many they are and how applicable they are for health practitioners when they're then looking to get a consent or refusal. So if that's advanced care directives, what is then a medical treatment decision maker? So a person, when they have decision-making capacity, can appoint a medical treatment decision maker who will then have the authority to make medical treatment decisions on that patient's behalf when they lose decision-making capacity. And as I've referred to before, and as the Act says quite strongly along the way, the patient's medical treatment decision maker must make the decision that they reasonably believe that patient would have made if they'd had that decision-making capacity to do so. So that's where it's the move away from the best interest principle. If you're not making a decision for someone because you think, well, that would be right for them, I think that sounds like a good idea for them, but that it's about knowing their preferences and values and making the decision that they would have otherwise made, which of course may now more clearly be refusing a treatment, not just consenting. The other thing I think to note with medical treatment decision makers is you're probably more familiar, for example, of a medical enduring power of attorney or an enduring guardian, or you may have a personal power of attorney with a healthcare authority. They are now known as appointed medical treatment decision makers. So someone who's made an appointment prior to the 12th of March for a medical enduring power of attorney with healthcare authority, or an enduring guardianship order, they remain valid and legal. It's just that they would now be known as an appointed medical treatment decision maker. And then the other component that the Act has, which is quite a new role, is the support person. Although the concept of support person may be familiar to some of you who know about the Mental Health Act or the Powers of Attorney Act, which have the roles of support person under them. So the support person's role is, as it says, to support the patient to make, communicate and give effect to their medical treatment decisions. And that support person can represent the interests of the patient in regards to their medical treatment, so it is limited to just medical treatment. The intention for the support person seems to be that a lot of our patients may not have family members. They may have a really supportive friend or a neighbour who might go to medical appointments with them. They may be someone who has a really good way of explaining medical information and medical treatment to the patient. But when they go along to a medical appointment, or if they try and ring, say, the GP after an appointment and say, look, my friend just went in, saw you, she wasn't really sure what you'd said, could you tell me and I'll help explain it to her? And doctors often then say, well, under the privacy legislation, I can't tell you if you're not a spouse or a family member. If someone has appointed someone as a support person, that gives a little bit more legal weight and authority to then allow doctors to disclose and obtain medical information. And you'll notice that it says that support persons can also access the health information of the patient, for example, through their medical record, although the Act does say it has to be relevant to that medical decision. So not wanting to get their medical records from 10 years ago when something happened, but to what's relevant to a medical treatment decision that's being made now. It's important to remember that a support person cannot make medical treatment decisions for that patient. They're only in that role of supporting. So if an actual decision is needed and that patient can't make it themselves, it will be the medical treatment decision maker that makes that decision. A support person can't step in to then take over. So with the advanced care directives, which have the values directive and the instructional directive, we've got the appointment of a medical treatment decision maker, and we've got the appointment of a support person. All of those under the Act have witnessing requirements in order for them to be a legal document. The Act itself doesn't prescribe forms, But what the Department of Health and Human Services, along with the Office of the Public Advocate, have done is have drawn up some forms that parties can then choose to use, because these forms will have the legal requirements and will explain about the witnessing that's required for each form. So people can go onto our website. They can take the Take Control book, which is quite familiar, I think, to a lot of people in the community, which has about the powers of attorney forms. It includes all of these medical forms that we're now talking about. Or you can go to the Vic Health website. So there are forms that people can choose to use if they want to. Doesn't mean they have to, but if someone's going to write up their own form, they would need to be really clear that they've met the requirements under the Act so that it does become a legal document. So that's why, if you remember earlier on, I talked about we know of things like advanced care plans or goals of care forms or end-of-life wishes. They are not transferable to now be an advanced care directive. They don't now automatically have the weight of an advanced care directive, because they would have had to have been done from the 12th of March and would have had to have followed the witnessing requirements that the Act prescribes. So the second part of the presentation is around medical consent. Now, that shouldn't be something new to you guys, because you've always been required as health practitioners to seek informed consent. The Act has a little bit of different language around that. It explains some of the processes a bit clearer, but the concept of medical consent is nothing new. So with the rest of these slides that we're going to go through, please remember that we're talking about patients who now lack decision-making capacity. Okay, so this processes of medical consent will only relate to those scenarios where the patient themselves cannot give their own decision to consent to or refuse that treatment. So, health practitioners, of course, need a patient's consent before providing that treatment, unless it's an emergency. So again, that's not new. Up until the 12th of March, health practitioners could provide medical treatment in an emergency without consent. There is a slight caveat to that, which relates to the advanced care directives, so we'll talk about that when we get to the definition around emergency treatment. And then the Act will also set out the consent process. So what does happen if a patient lacks decision-making capacity? What do health practitioners do in order to have a decision be made? So the Act defines health practitioners. So up until now, we've probably thought of doctors or dentists being required to obtain informed consent. The Act now defines any of those professions as being a health practitioner, and as such are bound by what the Act says around obtaining a medical treatment decision. How they came up with that list is essentially when they were drafting the legislation, these were the professions that were registered with AHPRA. So you'll notice, for example, that speech pathology is not on the list, and that's simply because they weren't registered with AHPRA, rather than saying speech pathologists shouldn't consider consent processes. Whether that changes with any amendments to the Act and the speech pathologists get brought in, we'll have to wait and see. And we'll need to be mindful that the Act also does apply to paramedics and the non-emergency patient transport staff. How common this becomes for different health practitioners, again, we'll have to wait and see what happens from the 12th of March. The starting point for the Act, talking about consent, is around decision-making capacity. There's a clear definition under Section 4 of the Act around what is decision-making capacity, and it is aligned again with what the Powers of Attorney Act and Mental Health Act refer to when they're determining decision-making capacity. So, of course, if we think about the Act applying to children and to adults, we know that adults are assumed to have decision-making capacity unless there's evidence to the contrary. For children, they're assumed not to have decision-making capacity unless that's proven to the contrary. So if we're thinking about adults, the starting point is that a patient would have that decision-making capacity if they can understand the information that's relevant to that medical treatment decision. So they're not saying that decision-making capacity is global and you can't make any decisions, but it needs to be specific to the medical treatment decision the health practitioner is talking about. So to understand that information relevant to the decision, that the patient can retain that information to the extent that's necessary to make the decision, that the patient can use and weigh up the information, and that then that patient can communicate their decision in some way of what that decision is that they've made. So if as a health practitioner you're finding your patients cannot do those 4 things and you consider they do not then have decision-making capacity, that's when you start going through a process of where you find a decision maker for that patient. The definition of medical treatment, so it's slightly expanded compared to the previous legislation. And there's 2 parts really to a definition of medical treatment. So to determine if something is medical treatment or not, there needs to be the purpose of the treatment to diagnose the physical or mental condition, to prevent disease, restore or replace bodily function, and improve comfort and quality of life. So probably fairly common understandings that we've all had around a purpose of medical treatment. The form of treatment is where there is a bit of an expansion. So still the treatment with physical or surgical therapy, but it also now includes treatment for mental illness. It includes treatment with prescription pharmaceuticals. So you need to now start thinking about the medications that you're prescribing to patients. Those medications require a decision to be made if your patient lacks that decision-making capacity. The Act will include being able to make a decision to an approved medicinal cannabis product, dental treatment, which I think has been fairly well known, and the Act does then say palliative care. That can be a little bit confusing where it says that a form of treatment is palliative care, because that would assume that if it's a medical treatment, that can be consented to or it can be refused. But the Act goes on under Section 54 to talk about the administration of palliative care cannot be refused despite an objection of a medical treatment decision maker. So similar to how it's always been, where palliative care is being administered and that person doesn't have decision-making capacity, that palliative care cannot be refused. What we're thinking is that for health practitioners, they're needing to be at times maybe a little clearer in terms of determining what within that palliative care plan is for palliative care, but what might in fact not be. So if you think of prescription pharmaceuticals, so if someone's in palliative care and they're being prescribed the morphine, and that's to relieve their pain and ease with their suffering, that's part of their palliative care treatment, that can't be refused. But if within that they're also being prescribed a medication for their cholesterol, that's not for the purpose of palliative treatment. And so a medical treatment decision maker, while they couldn't refuse the morphine, for example, could certainly refuse the cholesterol medication because that would be a medical treatment decision. So health practitioners needing to maybe be a little bit clearer in how they're explaining what they're prescribing being for the purpose of palliative care. Otherwise, that's medical treatment. So we talked at the beginning about emergency treatment. So there's a definition of emergency treatment, as there has always been. The definition talks about medical treatment that is necessary as a matter of urgency. So the Act doesn't particularly say emergency, it talks about urgency, although it doesn't define that any further. But it does say as a matter of urgency to save the patient's life, and I think that's pretty well known, that's fairly common out in the community. But it's also about being mindful that emergency treatment is a matter of urgency to prevent serious damage to the patient's health, or to prevent the patient from suffering or continuing to suffer significant pain or distress. So there may be scenarios, for example, where a patient may have fallen, they've broken their neck of femur and they're in hospital, and a decision needs to be made about having a surgery to repair that. It may be that doctors, when they are considering whether to treat this patient under emergency treatment or not, give consideration to all three of those points, not just point number one. So emergency treatment, as a definition, means that consent is not therefore needed. In an emergency, the health practitioner provides that medical treatment without consent being obtained. However, with now the introduction of the Advanced Care Directive and an instructional directive may have refused that treatment that is now being offered, even if it was an emergency. The Act talks about if, at the time of an emergency, the health practitioner is aware that the patient has refused that treatment in an instructional directive, the health practitioner does not provide that treatment. Of course, what becomes uncertain for health practitioners is, well, what's reasonable in those circumstances to know or to go and find if there's an instructional directive. The Act simply says reasonable efforts in the circumstances. So that is a judgment on your behalf as to what your situation is you're finding with the patient. Is there time to call the GP and ask if there's an instructional directive on file? Is there a family member that may be with the patient that can answer that question within the time frame that you need? So what we're trying to promote as a message is that health practitioners and health networks are thinking about having these discussions with patients sooner rather than later about whether they've done an advanced care directive. If they have, could a copy be put on their records? So that those discussions are happening now while there's not any urgency, there's no particular crisis, but that then becomes something that health practitioners know into the future. Again, so the patient's preferences and values and what they want to see happen for their medical treatment can be respected and followed into the future. So emergency treatment, obviously you don't need consent unless the health practitioner is aware of an instructional directive that has then refused that treatment. So where we've got a situation that's not an emergency and consent is required for a medical treatment, the Act actually sets out 3 steps of what you would go through as a health practitioner to follow when your patient doesn't have decision-making capacity. So that's step 1. So health practitioners at the starting point need to consider, is there an advanced care directive with a relevant instructional directive? So what they're meaning by that is, again, people may have done an instructional directive that refers to cardiac care that they may have consented to or refused in their instructional directive, but actually the medical situation, the treatment that you're wanting to provide is respiratory related. That instructional directive, while it may be there, is not relevant to the medical treatment that the patient's actually facing. So it's kind of knowing, is there an instructional directive, but then is it relevant? If the health practitioner finds that there is a relevant instructional directive, as the slide says, if they've refused, then the health practitioner would withhold that treatment or withdraw that treatment. If within the instructional directive the patient has consented, then the health practitioner administers that medical treatment. If it's clinically appropriate to do so. So the making of an instructional directive does not compel a health practitioner to have to provide medical treatment if they otherwise think it is not clinically appropriate. Okay, so that hasn't changed. Just because someone may have said in their instructional directive they do consent to that treatment, if as a health practitioner you don't believe it's clinically appropriate to offer that treatment, you're not somehow now bound to do that because it says so in an instructional directive. However, if you're at step 1 and there is no instructional directive, or there's not a relevant one to the medical situation that you're facing, and the answer is no, you need to go to step 2. So that's where it's about determining, is there a medical treatment decision maker? So similar to there being a hierarchy in previous legislation, there is a hierarchy again now. So the number 1 at the top of the list is if the patient has appointed a medical treatment decision maker. So from the 12th of March, that would be an appointed medical treatment decision maker. But if there is a medical enduring power of attorney, an enduring guardian with a healthcare authority, or a personal power of attorney with a healthcare authority, they would be seen as an appointed medical treatment decision maker, so they would still be number 1. If, however, there's no one at number 1, is there a guardian who's been appointed by VCAT, who has the power to make medical treatment decisions? So there will still be situations where VCAT have made guardianship orders for a guardian to make medical treatment decisions. If, however, in your patient's situation, there's no guardian either, they then go to number 3. Some of this might be familiar to some of you as what was called a person responsible. Under the person responsible list, it was much longer. It included grandparents, aunties, uncles, nieces, nephews. So that list has been shortened, but the concept remains that it's the first of the following persons who is willing and able, but the Act now says must also be in a close and continuing relationship. So the intention is instead of having a patient in hospital and they have a brother who maybe lives interstate, hasn't seen that patient for 10 years, wouldn't necessarily know anything about the patient, but by virtue of them being the first on that list, they somehow then had the authority to come in and make a decision for that patient. The Act's trying to recognise that really people should be in that close and continuing relationship. So it may in fact be that your patient has a scenario where they have an adult child and they would be first on the list, but they really haven't seen your patient much over the last few years. They're quite estranged, really wouldn't know how to get in touch or communicate with them. So instead of it being that adult child, there's also a sibling of the patient, and they're actually someone who sees your patient every day, helps out with supporting them to appointments or having dinner together once a week. They would be in a close and continuing relationship, so consideration is given to actually them being more relevant as a medical treatment decision maker, not the adult child. If, when you're going through number 3, there is more than one at any of those lists, then it would be the eldest of those persons, so the eldest child or the eldest sibling. So you've got to this step, you've found a medical treatment decision maker under that list. The medical treatment decision maker will then make the decision to consent to or refuse the medical treatment for your patient. If, however, there is no one under that medical treatment decision maker list, you need to come to step 3. Now at step 3, this is where as a health practitioner, you need to consider, is the proposed treatment significant medical treatment or not? The Act gives you a definition of significant medical treatment, so it's significant degree of bodily intrusion, of a risk, side effect or distress, and then the Act says routine medical treatment is anything that's not significant medical treatment. Now, why it's at this point a health practitioner needs to consider if it is routine or significant is because if that medical treatment is routine, then the health practitioner can provide that treatment without consent, as long as you're documenting that in the medical records. It's only where that medical treatment is significant medical treatment would it now come directly to us at our office and a decision can be made by the public advocate. Now, the determination of whether treatment is significant medical treatment or routine medical treatment is the determination of the health practitioner. So you don't ring our office and ask us, is this treatment significant or is it routine? As a health practitioner, you're the ones that make that clinical opinion. So if, as a health practitioner, you have determined that the treatment is significant medical treatment, you would then go on to the Office of the Public Advocate's website. You'll look for a Section 63 form. You fill that in, and that gets submitted online, and that comes directly to my team, the Medical Decisions team. So previously, you may have reached this stage and thought that an application to VCAT was needed to have a guardian appointed to make medical treatment decisions. At this point now, you can actually come directly to us at the Public Advocate's Office. By submitting that Section 63 form, which aligns to the part of the Act that gives us the authority to step in and make a decision, we can then become involved to go through and make a medical treatment decision. So if you're at step 3 and the treatment is routine, you've made that determination, you can provide consent, you can provide treatment without consent, as long as you're documenting that in the medical records. And if it's significant, that's where you're making contact with our office, and it is our office that will make the decision. So acting in good faith, there's still a component in the legislation that recognises that if a health practitioner is acting in good faith and without negligence, is reasonably believing they've complied with the medical consent process, a health practitioner won't be guilty of an offence or liable for unprofessional conduct or professional misconduct. So, to summarise those steps for where you're seeking medical consent, it's about needing to know if there is an advanced care directive with the relevant instructional directive, and if so, you follow what that instructional directive has told you about consenting or refusing treatment. If there isn't one or it's not relevant, you then have to search for a medical treatment decision maker, and if you find one, the decision is made by that medical treatment decision maker. If there isn't one, you decide, is the treatment significant or routine? If it's routine, you go away and administer that treatment without consent. If it's significant, you come directly to our office and we can make that decision to consent or refuse to the medical treatment. The other area where we may get notifications directly to our office, and this is a bit of a safeguarding under the Act, is if, as a health practitioner, you have a patient, they do have a medical treatment decision maker, so you're not coming to us to be the medical treatment decision maker, there is already one, but they've refused the medical treatment that's being offered. And as a health practitioner, they're concerned that the preferences and values of that patient are not known or couldn't be known or inferred by that medical treatment decision maker. So it's left the health practitioner unsure how they came to make a decision to refuse, being that often refusing treatment has fairly significant consequences. So the health practitioner can notify us directly under Section 62 of the Act, and we will essentially do like an investigation. If we form the opinion that the medical treatment decision maker made a decision to refuse treatment that was not unreasonable, then we won't notify VCAT. But if we came to an opinion that that refusal by the medical treatment decision maker was unreasonable, then our office will apply to VCAT, and VCAT will then make an order or an advisory opinion on what the medical treatment decision should be, whether the medical treatment decision maker continues to be making those decisions. Again, finding more information about that or the forms to use are on our website. Now, the Act covers a whole lot of other things, not all of which can be in a presentation. but to note that the Act does go through a process of where the patient is likely to recover within a reasonable time. So again, the Act is wanting wherever possible for the patient to be making their own decisions. So if there is a situation that will allow the patient to be recovering, then making a decision should wait until that patient can make it themselves. Talks about when a health practitioner may administer palliative care, which we've talked a little bit about. There is still the concept of futile or non-beneficial treatment. So again, as a health practitioner, if it's your clinical assessment that the treatment is futile, that it's non-beneficial, again, you're not required, you're not compelled to be offering that. And the Act also goes through the consent process for medical research procedures, as there are often patients out there who don't have decision-making capacity, but they can still engage in the medical research. So for more information, as I've talked about, certainly our website has a lot of information on all of the topics that have been talked about here. And the Health Vic website has a medical treatment planning and decisions page. Some of you may know our office also has a telephone advice service. As a health practitioner, if you have a question that relates to medical treatment or relates to the Act, when you call our office, you can speak directly to a medical advice line. If your questions relate to anything other than medical treatment, you still need to go through the general advice line. But it is recognising that with this new Act, there may be a number of questions that you still have, which is absolutely fine. And so please feel free to call us so we can try and answer them and work through them further with you. So that, trying to be in a nutshell, is a presentation on the Medical Treatment Planning and Decisions Act. And we can now take some time to ask and answer some questions. Yes.
Sonia, thank you very much for your presentation. With regard to advanced care directives, if my patient has one, but I think it's a bit unclear or I'm a bit confused, I'm not too sure whether it applies to that specific situation, can I get advice or seek direction from someone?
Yes. So in those scenarios where you're needing to have a determination on the meaning, the validity or the effect of an advanced care directive, you'd actually make an application to VCAT, as its VCAT would then make an advisory opinion or make an order on the advanced care directive. It wouldn't be at our office, so an application to VCAT. Okay.
In relation to if someone can't consent to treatment and there's no other medical decision treatment maker, what does the public advocate do? How do they make that medical treatment decision for the person that they don't have any information on really?
Essentially, the public advocate, same as any other medical treatment decision maker, be that someone who's appointed or is on the default hierarchy, we have to follow Section 61 of the Act. So we need to have an understanding of the patient's preferences and their values. We need to know what the effects and the consequences are of the medical treatment. We need to consider, are there any alternatives, whether refusing treatment might be more aligned with the patient and what they may be expressing as a preference, or from what we've understood to be valuable in their life about their health care. So there's a clear process that we have to follow, but it is actually the same as what any other medical treatment decision maker should be doing.
So Sonia, just going back to the appointment of the support person, can the appointed support person be the same person as your appointed medical treatment decision maker?
The short answer is yes. If the patient chooses to appoint the same person to be the support person and the medical treatment decision maker, yes. It may be that patients do appoint one person as their support person and someone different as their medical treatment decision maker. It could also be that a patient decides to appoint a support person but doesn't appoint a medical treatment decision maker. So again, it's about with the patient's life and their lifestyle, what they think works for them. So it's about being clear as a health practitioner, if you are talking to parties, to maybe just clarify, are you in an appointed role as a support person, medical treatment decision maker, just so that you can be clear on who can and can't do what.
Okay, great, thank you.
Yes.
Where do our patients register their advanced care directives or their appointment of a medical treatment decision maker?
Unfortunately, there's no central point to register advanced care directives or the documents for an appointed medical treatment decision maker, similar to how there's no registry point for enduring powers of attorney. So what it requires is talking to the patients about making sure that they have communicated that they've made one to someone. They might want to give a copy to their GP, or if they do regularly go to a hospital, that they leave those documents on record there. So it's a matter of talking, I suppose, to your patients about, now that you've done these documents, how are you going to make sure that other people know about them? Because unfortunately, as health practitioners, there's nowhere you can go to check. Yeah. Are there any more questions in the audience? Yep.
Sonia, can you please explain who makes the determination if the medical treatment is emergency treatment or not?
So the determination of emergency treatment is made by the health practitioner. So following the Act's definition of emergency treatment, it's the health practitioner to be satisfied if it's a matter of urgency to save a person's life, prevent deterioration of their health, or to prevent the suffering or continuing to suffer significant pain or distress. So it's not that a health practitioner would call our office to check, to ask if they're on the right track, or to ask us to make that determination, because it's a clinical opinion of the health practitioner who's there at the time offering the treatment to determine if it's an emergency or not.
Thank you.
Okay.
What happens if there's conflict as to who is the medical treatment decision maker?
So where there's conflict in families, and of course we know that's always going to be, and the Act doesn't particularly fix that for us. If there's dispute amongst certain family members, for example, that are saying, well, I'm the medical treatment decision maker, somebody else says, no, I fit higher on the list. It's really a matter of taking that again to VCAT, and VCAT would be the arbitrator to determine whether one of those parties may be a medical treatment decision maker, or whether VCAT may need to appoint a guardian. They may appoint a guardian that is one of those family members that are promoting themselves as the medical treatment decision maker, or they potentially could appoint the public advocate, and our office would become involved to make those medical treatment decisions. So again, depending on that scenario, if that dispute cannot be resolved any less restrictively, then it's an application to VCAT and they'll work through that.
I was wondering who assesses a patient's decision-making capacity. Does it need to be someone like a neuropsychologist?
So the Act doesn't say that it has to be a neuropsychologist or a geriatrician or any other specialist. It talks about the health practitioners who are needing to obtain consent from their patient, needing to determine and be satisfied about decision-making capacity. In saying that though, of course, if there's some significant dispute or uncertainty around the patient's decision-making capacity, you may find that it would be helpful to refer on to a specialist to give a more detailed or a more thorough assessment. So again, it's about using your judgment at the time as to whether you're able to satisfy yourself of decision-making capacity or it needs to be referred on.